First is House File 1520 from Representative Hemmingson Yeager. As you come down, I will move House File 1520 be recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. And Representative Hemmingson Yeager, you have an author's amendment, the A1 amendment, which perhaps we can adopt first before going to your opening remarks. The A1 amendment being an author's amendment, I will make the motion for the A1 amendment. Any discussion to the motion? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and A1 is adopted. Representative Hemmingson Yeager, to your bill.
Great. Thank you. Good afternoon, Chair and members. My name is Amanda Hemmingson Yeager, new representative, but I am also trained and experienced as a geneticist. So very excited. I have a master's in genetics. Very honored and excited to kind of be offering this bill, which is about direct-to-consumer genetic testing. If anybody wants to light reading later, I also did my own paper on it at the Humphrey, so very well versed in this type of information. Overall about the bill, I want to be concise and succinct, being a scientist. It's a very collaborative project. I've been working with people from the industry, people with health privacy rights activists, both DFLers and GOPers. It's bipartisan, and basically we all know that genetic testing is becoming increasingly more powerful, and it's becoming increasingly more in use. This specifically focuses on the direct-to-consumer genetic testing. So these are things where you get a kit, you can spit into a tube, you can send it back to the company, and they can do a whole host of things that their company advertises, from finding ancestors to finding your evolutionary roots to your potential increase in health risks. Basically, this bill overall, and I can have my testifiers expand more on it, but in a nutshell, it lays out the expectations that a consumer can have for their privacy when it comes to genetic identity. And it also lays out expectations from the direct-to-consumer genetic testing company itself. So again, I'm very well aware of what we're doing with this type of technology. If you lose your license, you lose your social security card, you can get those back. You lose your genetic information, that is you can't really get a replacement genetic genome. So with that, I can have the testifiers come down.
Great. We do have several people who signed up to testify. Excuse me. The first is Richie Engelhart. Come forward, state your name for the record, proceed to your testimony. Welcome to the committee.
Good afternoon, Mr. Chair and members. Thank you. My name is Richie Engelhart. I'm the head of government affairs at Ancestry, and I'm here today on behalf of the Coalition for Genetic Data Protection in strong support of HF1520. Ancestry is proud of the work that we have done with our coalition partners, including 23andMe, to implement common sense privacy protections that ensure all consumers are in control of their genetic data at all times. Together with privacy advocates in the Future Privacy Forum, a leading nonprofit that focuses on privacy thought leadership, we developed what we believe are the appropriate guidelines for direct-to-consumer genetic testing services. This includes ensuring consumers provide separate express consents, meaning we cannot bury the consents in our terms of service or privacy policies for any collection, processing, or sharing of their genetic data. The bill would require separate express consent for all of the following: analyzing the consumer's biological sample, storing the consumer's biological sample after it's been analyzed for future testing, and I'll note that's completely optional. If the consumer does not want their sample banked, they can still participate in the company's services. Viewing genetic relatives on our websites, and both parties have to consent to that or that match is not revealed, so it's actually a double opt-in. Using a consumer's genetic data for marketing purposes, and I'll note neither Ancestry nor 23andMe do this. It doesn't pass the creepiness test. But if there is a company out there that wants to use genetic information for targeted marketing purposes, this bill would require them to get a separate express consent for that. And for research, if a consumer opts in for research, they actually get kicked into an informed consent process, and that informed consent explains the benefits and the risks of research, and this is the same as any clinical trial that's conducted in the US. It's governed by an institutional review board. All of the common rule provisions would apply to that research. And then sharing their data with any third party for any reason. So aside from the consents we must collect from consumers, they're empowered to delete their data at any time and have a biological sample that they previously opted to have stored destroyed. They can end their relationship with our companies and have their data and samples deleted, and we retain no rights to it whatsoever. This bill puts these protections into law, outlining our responsibilities to Minnesota consumers and clearly explaining their rights when they engage with direct-to-consumer genetic testing services to learn more about their genealogy or health. This approach has broad bipartisan and stakeholder support. Since 2021, 6 states have enacted similar laws, including Arizona, California, Kentucky, Maryland, Utah, and Wyoming. And aside from Minnesota, 10 other states have similar measures in progress this year, Virginia being the furthest along. And while Ancestry and 23andMe have adhered to these practices the entire time that we've offered DTC genetic testing products, this bill will ensure that every direct-to-consumer testing service is held to the same standards for data protection and privacy. Our consumers' trust is our top priority. If they don't trust that we are employing strong privacy standards for their genetic data, they simply won't use our service. So we urge a favorable report on the bill, and I welcome any questions the committee may have.
Thank you. Our next testifier is Rich Neumeister. Mr. Neumeister, come forward, state your name for the record, proceed to your testimony.
Would it be possible if someone could pass these out?
Yeah, I think we have
That'd be
a
much
committee
obliged
pages
to
can do
you,
that
sir.
for you.
Mr. Chairman, members of the committee, my name is Rich Neumeister. I'm going to be speaking with you about 4 basic things about this bill. Now, this bill came in as a model bill. And so what's happening is folks are trying to improve privacy and consent provisions from a Minnesota perspective, like other states have done. Number 1 issue is enforcement. Your committee won't be handling it, but it's important for you to know that there's talk about a right to private action. We, in our law, at 13.386, have a genetic privacy law that deals with almost everybody. But it's in the Minnesota Government Data Practices Act. And so on the Senate side, and with the amendment you're adopting here, it refers to that. That's still a thing in discussion, how to do that right of private action or something like that as it heads to the other committee. Secondly, definitely, this is under your jurisdiction. 45027, if you see on the last page, is the enforcement provision with the Department of Commerce. I have some concerns about that. One is that in other states that have had this kind of enforcement, if the complainant is found in their favor, they get part of the fine or whatever it is. So I would like to suggest that if the Department of Commerce takes someone and then there's a amount of money that they get, rather than go to the general fund to give the person whole, that should go to them. The 4th point, and to me a very important point, is if you look at the bill on lines page 3, 14 through 17, you'll see general consent provisions. And with the handout that I shared with you, you'll see 2 references to California and also Virginia, which is right now on the verge of passing similar legislation. And you'll see at the bottom language that I'm suggesting be changed from the written language, which is on top of the line page. The way the consent provision is now is just a very general kind of provision. You will, what California and Virginia and that what I think we should have in Minnesota, with their most private of all data, our DNA, we should be able to approve of use every time it's outside of going to third parties. We each use. Number 2, we should have the name of who that individual of that party is. And so that is one area that I know, Mr. Chairman, that the chair, who's been great to work with, is still entertaining as this bill goes fast. I think it's just important, my last statement, in any of these, it's an issue, is consent for the individual on this most part of ourselves should be freely given, specific, informed, and unambiguous. Parts of this bill, and particularly the one that of the consent that I just shared with you, which I have a problem with, is opposite of that. It's ambiguous, doesn't really give no knowledge for the individual, and it's broad consent. Mr. Chairman, members of the committee, I thank you very much for the few moments of your time.
Thank you, sir. Next, we have Natasha Tunievsky. Come forward, state your name for the record. Proceed to your testimony.
Hello, thank you, Mr. Chair, members of the committee. My name is Natasha Tunievsky. I'm the Legislative and Policy Specialist for Citizens Council for Health Freedom. CCHF has long supported genetic privacy rights, and today we are very thankful for this conversation taking place and for Representative Hemmingsen-Yager's work. On this bill, we've had multiple conversations, both with her and on the Senate side with Senator Klein, about our concerns for this bill, and that namely that this bill doesn't specifically give protections for a few areas of genetic privacy, and we are concerned that it would give consumers a false sense of security. As I mentioned, we testified on this bill on the Senate side, and we are very thankful for the amendments that were adopted there and then also brought forward here. However, we are still deeply concerned with line 2.25 of the bill, which states genetic data does not include de-identified data. The bill's intent is to give consumers protection over their genetic data. However, line 2.25, under it as it stands, the companies will only be obligated to protect a subset of consumer genetic data. Anything that is de-identified may be shared without consumer consent. Those specimens and any related data will be exempt from the protective provisions of this bill. What is even more concerning then is when we realize that, as noted by 23andMe, if this data, this de-identified data is breached at any point in time, it can be re-identified using a public database. So there's really a huge lack of security and potential privacy for the consumer. As Representative Hemmingsen-Yager mentioned in her opening remarks, once you lose your genetic privacy, you can't get that back. And so we are deeply concerned at the potential for that to happen, and the lack of consent requirements over de-identification and the lack of protections offered in this bill over de-identified data. Our second concern is on lines 3.20 and 3.21, which states that Minnesota policy regarding consent for research is to be defined by the federal common rule for federally funded research. Thus, this bill would transfer authority to federal officials to determine the definition and even the need for obtaining consent for any potential research or data sharing. The common rule provides 4 reasons that consent requirements can be waived, including whenever an IRB decides that there's minimum risk to the individual. That should be an individual's decision, not a corporate IRB decision. Minnesota should not cede authority to an unelected federal official who could change consent provisions with every new administration or in line with industry lobbying. Finally, if this committee intends to pass the bill, we have 2 more suggestions to strengthen consumer protections, in addition to our request that lines 2.25 would be deleted, and also the request that reference to the common rule would be taken out, both of the bill and now of the added amendment. First, require informed consent specific to de-identification of the specimen. The consumer should be informed that they lose all rights to where it goes and what happens once it's de-identified, and that they have the choice as to whether it's de-identified and used in the first place. Second, on line 4.4, give consumers access to all accounting of disclosures so they know with whom and how often their information is being shared. Again, thank you so much for the opportunity to testify, for your concern and interest in this bill. We do believe that it's important to protect genetic privacy, and these are just our suggestions to make this bill something that does protect consumers, that is a strength to their privacy all the way through, and there's not a subset of their DNA left unprotected. Thank you again for the chance to speak today.
Thank you. That concludes all of the people who signed up to testify. Are there any members of the public wishing to testify to this bill? Seeing none, we'll move to member discussion and questions. Members to the bill. Representative O'Driscoll.
Mr. Chair, before questions, just a little bit of background. Where is this getting referred to from here?
To Judiciary.
And how many more committee stops does it have?
I believe that probably is it. I think that's probably the only one.
Okay. That's good for background. I'll wait until others have had a chance to ask questions before I share my thoughts. Thank you, Mr.
Sounds
Chair.
good. Representative Niska.
Thank you, Mr. Chair, and thank you, Representative Hemmingsen-Yager. My first question, I wanted to start with what Ms. Tunievsky was talking about with the federal common rule on page 3, line 20 and 21. And maybe you know the answer to this, or maybe a researcher can help us. If we deleted the reference to the common rule and just said informed consent is required, What would be the meaning of that under Minnesota law, if you know, or if someone,
Representative Hemmingson
No.
Yeager, if you can answer, otherwise we can ask nonpartisan staff if they can help.
Yeah, I'm going to refer to nonpartisan staff if that's okay.
I don't know, I don't think we have an answer to that question
Okay.
So
right in front of us, Representative Niska.
being
Representative
the-
Hemmingson Yeager.
that being the case, I will give my understanding of this. So this particular common rule does regard like human resource subjects. So my only concern then would be having state law conflicting with federal law when it comes to that specific type of person.
And in Representative Niska, since you're on the Judiciary Committee, perhaps you can follow up with nonpartisan staff and they can get you an answer before you see the bill again.
perhaps we could.
President Niska.
Yeah, thank you, Mr. Chair. My next question, I guess, is something that was raised by Representative Neumeister about, or by Mr. Neumeister about,
Sometimes it feels that way.
exactly, about the remedies here, and he referenced potentially the Commerce Department giving something to individuals who are injured. And my understanding of the way this would work is it would essentially create some part of the contract between the company and the individual, and they would most likely have some sort of breach of contract remedy as well as whatever Commerce Department remedy this is creating. Is that the intent of this bill, is that it's going to kind of supplement the contractual obligations between a consumer and an individual company so that the consumer would at least have also a breach of contract claim against the company if they break the law?
Representative Hemmingson Yeager.
If you're asking what I think you're asking, no. This is not meant to supplement any sort of contract between the consumer and the company. The part about Mr. Neumeister's suggestions are still being worked on. I'm working with Representative Scott to figure out exactly how we can do this the best way possible to make sure that consumers are protected, but also my experience working in a lab, understanding what happens in a lab with these biological samples. So if that answers your question or not.
Representative Niska.
Thank you, Mr. Chair, and Representative Hemmingson Yeager. I'm not sure it does, and I think this actually is good for the bill that their terms of service, whenever a customer clicks on the terms of service, they have to agree that they're complying with all applicable laws, and I think this just actually beefs up the terms of service if they don't already contain all of these protections in the contract between the customer and a Minnesota customer and a company. I think this bill is going to sort of raise the standards that they have to meet in their contract with them. So that's all I was trying to get at. Does that make more sense? Does that clarify my question? Maybe that.
We'll see.
All good? Representative Niska?
Yeah, that's all for now.
Okay. Representative Cleveland. Oh, Representative Hemmingson Yeager.
Yeah, may I respond really quick?
Of course, yeah.
Okay, so perhaps Mr. Engelhart, if he's still here. Okay, he could probably speak better to the actual company itself. My understanding is that under 45.027, that does give Commerce some sort of civil investigatory process. So that's kind of where we would see that housed on the state side.
Mr. Engelhart, did you have something you wanted to add to that?
Thank you, Mr. Chair and members. Yes. So our privacy policy is a part of our terms of service, so you're absolutely correct. If we were to violate our privacy policy in any way, it would be a violation of the terms of service. Standard tort law would apply.
Representative Niska, anything to follow up there?
No, Representative Stevens, Mr. Chair, I appreciate that. That's exactly what I was hoping the answer was, that there is still some way that an individual who has been injured has some legal remedies that this is bolstering, as well as the Commerce enforcement power. So thanks.
Great. Representative Cleveland.
I'm sorry, I have to turn my back to you. I want to say thank you for bringing the bill forward, and I appreciate the comments that we heard from both of the other two testifiers. You know, privacy is something that's very near and dear and important to me, and so at least in bringing this bill forward, are you then just letting the general public know that there are concerns with privacy currently in the direct-to-consumer market? And by making, this would be I guess I'm asking for clarification. This says to the consumer, you need to opt out or these protections will be in place. Is that correct?
Representative Hemmingson Jaeger.
So my intention with this bill is, coming from a space where it's very complex, very fast-moving information such as genetics. Like I said, it's a very increasingly powerful tool. I can go back and see, my increased risk for heart disease or where my ancestors came from. But making sure that the public understands what they're getting into. So by each of these, it's laid out in the bill, but by prompting the consumer to go through a series of screens and say, this is what this means to be going into research. Yes, I accept, or no, I do not. This is what this means to say, I am giving you my biological sample, yes or no. I would like you to store my biological sample, yes or no, so that they understand kind of each step of the process, so that there's no surprises.
Okay, so
Representative Cleaborn.
thank you, Mr. Chair. So it's kind of an educational vehicle for the consumer as well as a protection for the consumer. Is that correct?
Representative Hemmingson Jaeger.
Yeah, I think so.
Representative Cleaborn.
Thank you very much, Chair. I have no further statements or questions.
Representative O'Driscoll.
Thank you, Mr. Chair. Just very briefly, everyone wants their data protected, whether it's in genetics or their credit card or whatever the case may be. And we always hear about different breaches of things that occur. I have concerns today about where we are at in this bill, and that's why I asked about where we were going with the Judiciary Committee. I am hoping that we can continue to work to get some of these other open and unresolved questions resolved. Some of the things that Mr. Neumeister brought up. He has been here for quite a long time and has been quite the advocate for data privacy and things here at the legislature, and probably will be here long after many of us are gone as well. He's just that dedicated to the mission. As a matter of fact, I heard his contract with himself is that he will stop being down here 2 years after the time he has passed away from this earth. So he plans on being here for quite a long period of time. So, Mr. Chair, unfortunately today I have to be a no vote because I don't think it's in a shape that makes sense for us to move it. But again, knowing that I can always change that vote should I see a version of the bill that I like when it makes it to the Minnesota House floor. Thank you, Mr. Chair.
Thank you. Representative Hemmingson Jaeger, I'll give you the final word.
Thank you so much for the discussion and for the questions. I'm here if you have any more questions. Representative Driscoll, if you want to meet, be happy to talk a little bit more and hash some things out. It can be really complicated when you start really diving into the nuts and bolts, but that's why I'm here. So we appreciate your support and thank you.
All right, and with that, I will renew my motion that House File 1520, as amended, be recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. All in favor, say aye.
Aye.
Opposed?
No.
Motion prevails, and House File 1520, as amended, is recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. Thank you, Representative Hemmingson Jaeger.